nonprofit that might be of interest to this group. It's the work of Nick Morgan and Tom Zaccaro of Paul Hastings, and it'll be rolled out this year. We'll have a short video, and let's roll it. There you go. All right. Thank you, Nick. All right, so next panel, the SEC's focus on cybersecurity, disclosure enforcement, key guidance for 2022. We have the perfect moderator for this panel in Rob Cohen. Rob is a partner at Davis Polk in Washington, D.C. And of course, Rob previously led the SEC's cyber unit, and before that was co-chief of the market abuse unit. Really pleased to have Rob with us here today. Welcome, Rob.
Thanks, Bruce.
To Rob's left is Susan Resley, the leader of Morgan Lewis's San Francisco litigation practice. And she previously served in the SEC's enforcement division, which she joined right out of law school, if I'm not mistaken.
Long time.
Today, Susan's clients range from boards to audit committees during investigations, public companies, C-suite executives during litigation and class actions. Welcome, Susan.
Thanks.
To Susan's left, we have Luke Tenery, who's a partner at StoneTurn. His perspective will be very interesting on this panel, as he is a consultant with nearly 20 years of experience helping organizations mitigate complex cybersecurity, data privacy, and data protection risks. He's also a certified Chief Information Security Officer. This is the right man for this panel. Welcome, Luke.
Thank you.
Finally, welcome to Brent Wilner. He's a member of the SEC's Crypto Assets and Cyber Unit, which continues to rack up victory after victory. Brent's also a former deputy AG in California. Great to have a member of the cyber unit on this panel to provide some frontline information on what's going on. So welcome, Brent, and thank you.
Thanks.
Rob?
Great. Thanks, Bruce. And it's a little-known secret that in organizing these conferences, Bruce puts the most important topics towards the end of the day. It's like the milk in the back of the supermarket. Like, you got to go through the whole store to get to what you really want. So you're finally here. Welcome to the cyber panel. I think in all surveys you see what keeps CEOs and boards awake at night worrying. It's cyber. I hear that all the time. You see in panels. So important topic and great to be here with the panelists. Let's start with Brent. I think there was some reference to the changing title of the unit and some changing staffing. So I don't want to repeat that, but want to follow up a couple specific questions I know I get about the changes to the unit. So first question, when we created the unit, there was no external hiring. It was all moving people from different groups, and you can imagine the arm wrestling that went into that. Brent, for the recent increase in staffing for the unit, is it the same thing? Is it people being moved internally, or is there external hiring to support the group now?
Yeah, so this is a good time for me to give the caveat that these are my personal views and not the views of the commission or any individual commissioners or its staff. It's an honor for me to be on this panel with Rob, who obviously was the first chief of the cyber unit and an amazing boss. And now we have expanded into being the crypto assets and cyber unit, but I think maybe the easiest way to answer Rob's question is the word cyber is still in there. The expanded unit enhances not only the agency's efforts with respect to crypto assets, but as the press release announcing the new name called out, these are enhanced resources to also focus on our enforcement efforts with respect to cybersecurity. And those have been ongoing since Rob was at the helm, and we've built expertise. And adding these resources, as a member of the unit, we're very appreciative. They are new resources, which is amazing. So for some of the positions which you may have seen public postings about, they're actually calling for candidates from the public, and if any of you are interested, some of them are still open, and I'm sure there's a lot of great candidates in this room. But adding an additional senior officer and adding additional resources at the investigative and trial levels, adding additional supervisory resources. It's amazing, and it will help us, again, not only for our crypto asset work, which is critical and which has obviously exploded in the last few years, but also in the cybersecurity space.
Great, great. And so one other question, I think one of the things that stood out to me as maybe most important from the announcement, besides the increased resources, which is obviously important, is the reference to trial attorneys. Going back to the creation of the initial 5 units in 2010, the units have never had dedicated trial attorneys. They would use the trial attorneys of the office, either in headquarters or the regional office. And it's not for lack of trying. The units have always wanted, dedicated trial attorneys who are experts in their area. And it's long been the decision of no, the trial attorneys, sort of support the entire office, not just a unit. So Brent, and so it caught my eye when the press release referred to trial attorneys. Are there now dedicated trial attorneys for this unit?
Yes, there are. And this came up a little bit on the crypto panel earlier. I mean, in large part, it's a recognition that litigating a case involving complicated crypto assets or involving cybersecurity, it takes a sort of unique skill set, right? Because you need to be a great litigator, just like all of our trial attorneys are, but you also need to bring to bear some experience in the industry. So, obviously a lot of the unit's resources on the trial front may be taken up by crypto assets, but I think there's going to be a space where, we will have certain cybersecurity cases, cybersecurity enforcement cases that also will go into litigation. And again, that's, it's a really unique skill set that you need to have to be able to kind of combine those two worlds, communicate, understand the complexity of these issues, and then communicate it to a finder of fact in a way that is persuasive.
Great. And my last question about the announcement is, obviously it has a big focus on crypto. So cyber is still in the title, it now comes second. Is there any shifting in priority away from cyber and towards crypto?
No, I mean, again, I think crypto assets, look, since the advent of the unit, crypto assets have been a component of the unit, and I think this is just a sort of a very explicit recognition of that, and it's also a recognition that, one, it's been a big priority for the chair, and two, just the explosion of the crypto space since the unit was started. But again, the press release announcing the expansion of the unit was very clear that these added resources will also help on the cybersecurity efforts. And look, in the unit now, we'll be close to 50 people. There's a lot of great expertise that the unit has built since you started it, Rob, that really go both to the crypto side, but also to the cybersecurity side. We have really talented staff that can handle these complex disclosure issues, that can handle the complex registrant controls issues that we're going to talk about. And so we expect those resources to be a big boon to those efforts as well.
That's great. That's great. It's funny, I think back to when we were first mapping out what the new unit would be, and I literally remember the conversation of, oh yeah, and we're thinking of putting crypto in it also. This was like shortly after the Dow report, there hadn't been any cases yet, and it's like oh, by the way. And just, my time there, obviously crypto played a huge role, and since then it's only gotten more and more. So let's focus on cyber. I think one of the most important areas for cybersecurity for this audience and for the commission is with public companies. And there's different aspects of how cybersecurity impacts public companies. Brent, let's stay with you, and then we'll go to Luke and Susan. So one area is disclosure, right? Straight up disclosing events or disclosing risks in the risk factor section. I think there may have been a mention previously, but can you talk about the recent case involving disclosure of a cybersecurity issue?
Sure. Yeah. And so just to step back one second, right? In a recent speech that Chair Gensler gave, that he titled Team Cyber, he really emphasized that cybersecurity is important to all three parts of our mission. And when we think about it from an enforcement perspective, there's really two buckets, right? There's registrant controls, there's registrant cybersecurity controls, which we'll talk about a little bit later. And then there's this part of issuer disclosure. And there's a few aspects to that. We think about what companies are saying about cybersecurity risks and events, whether they're doing so in a timely and complete fashion. And then in addition, there are sort of adjacent control issues that come up from that. There's disclosure controls and procedures issues. Lori mentioned on the last panel about the First American case, which we'll talk about. And then there's also insider trading and manipulative trading issues that come up around public company disclosure issues in the cybersecurity space, trading in advance of cybersecurity incidents that haven't yet been disclosed. One case that is sort of in the core disclosure bucket that happened, that the commission issued earlier this year is the Pearson case. So this was a London-based educational services provider, and there was a 2018 cybersecurity breach that resulted in the exposure of millions of student records. So right off the bat, I think this kind of sends the alarm of this is really critical, sensitive information that I think sort of we can all agree none of us want our students' records in the hands of cyber criminals. And the company was aware of the incident, aware of the type of information that had been exposed concerning the students. But in a July 2019 semi-annual filing, it's a 20F filer. So in a July 2019 semi-annual filing, they characterize the risk of such a cyber event as hypothetical, and similarly in another statement, characterize the type of information that could have been taken as part of the incident as hypothetical. And so, in some ways, I think this case really follows a pattern of what we've alleged in our major cybersecurity disclosure cases to date. So thinking back to the Yahoo case, which was really the first big case in this space, the Facebook Cambridge Analytica case, all of these cases really focused on this notion that if you're going to speak to the market and you're going to characterize your risk related to cybersecurity, and you do so in a hypothetical way when you already have information to indicate that you already had that exact risk manifest, that's going to lead to our raising concerns about it from a disclosure perspective. Maybe this is a segue to the disclosure controls and procedures point, which is that in all of these cases, in Facebook, in Yahoo, and in Pearson, and then we're going to talk about First American, I know, we charged 13A15, right, which is the disclosure controls and procedures provision. And I really, this is probably a theme I'll mention a couple of times today, but I think this is really critical, right? Because what you have here is sort of this disconnect between the real cybersecurity experts, the people that can, the CISOs that understand the nature of the incident, the nature of the nature of the breach, the nature of the information that's been exposed, and the people that are making the disclosure. And I think what these cases really get at is, I think public companies need to be mindful of how they can bridge that gap, right? And that's sort of what the 13A15 charge kind of goes to.
Great, and that's a great transition. Just one comment about the Pearson case. I know I found it very helpful in advising clients on this issue, and not limited to the cyber context, of hypotheticals. Right? I find that this has come up all the time, which is, we disclosed that issue. It's like, well, you got to read that carefully, right? And the risk factor, is it disclosed as, this has happened and may continue to happen, or is it just disclosed as this may happen? And as much, I think clients sometimes view that as like, boy, that's slicing it kind of thin. Is that really that important? Well, you point to the Pearson case. Brent, you mentioned the disclosure controls. Luke, if I could turn to you, there was a case brought recently highlighting disclosure controls and as they apply to cybersecurity incidents. Can you tell us about that?
Well, first, from my perspective, it's either intimidating or liberating to sit next to Brent, because he actually did the investigation on this one. So I don't know if he'll correct me or not in terms of speaking on investigation. But it was an interesting one from...
The staff went crazy on that case, by the way. It's well known.
Yeah. A few interesting points, and just kind of keep in mind, my take might be slightly different from, say, a legal interpretation standpoint. But I'll probably, just by virtue of how I work with counsel and clients, I'll speak to really just sort of elements also of operational impact, perhaps, that ultimately drive some of the key issues, perhaps, that legal folks or investigators have to deal with. But First American, interesting case in that the client ultimately, or in this case, the victim company, was sort of made aware of a public notification. So a news reporter went to First American, had identified some level of data exposure, particularly related to records under their care. These have happened pretty frequently over the years. And we know typically with a client like a First American, they're dealing with a pretty significant technology operation, so heavily application-centric, probably on a regular basis dealing with a variety of making sure the application works, maintaining some level of operational integrity to keep the business going. But ultimately, it's somewhere along the way, the organization had actually had some level of a vulnerability assessment report or series scans done that also had identified this vulnerability. And ultimately, there was some level of disconnect, I think, procedure-wise and according to their policies, to where different types of internal notification did not happen well, particularly to senior management, as a result of them being aware that this vulnerability existed. The series, I guess, of disclosures and statements that they made gave some level of inconsistent message in terms of what was known when and by whom. And the SEC had, obviously made some level of correction enforcement out of that. Why does something like that happen, I guess, in terms of the perspective and value that I can speak to is, one, there is sort of a broader issue at play here where organizations increasingly, depending on the type of organization they are, their reliance upon technology, how they look for vulnerabilities in their systems. In some cases, they're actually doing certain aspects of those vulnerability assessments under the oversight of counsel in many cases to do some level of assertion and/or oversight of privilege for some of those for these very reasons. So if a breach occurs, the organization had some prior knowledge of a vulnerability, it does give the organization some benefit of sort of control of that information in that sense. But I think many organizations reacted very sensitively in the sense of how they proceed with some of their vulnerability assessments at that point. And I just think that's sort of a notable thing that from a reactionary perspective, how organizations responded, but it also spoke to the obvious issue of what senior management is aware of, what constitutes their level of visibility. We'll talk a little bit more about materiality in a second and other aspects of the governance aspect of new topics of interest by the SEC. But ultimately, senior management having visibility into these types of issues obviously was elevated in that sense. And they had SEC determined they had a greater duty to not just disclose that, but sort of have general awareness of some of those key issues.
Yeah, I think just, again, generally, especially in cyber, but more broadly than that, we're just seeing disclosure controls more and more be a focus of the Commission's intention in investigations. And, one thing I start when I talk to clients about this is I say, okay, if the Commission called tomorrow and said, show me your disclosure controls, what would you show them, right? And how comfortable are you in showing them that? It's just an increasing focus, especially on cyber. But Susan, I think one of the most interesting topics to me for this panel is what you're going to talk about next, which is the SolarWinds investigation. And I find it, so interesting because we're going to have a lot to say about an investigation, but that's it. It's an investigation, and it was, unusually public, the fact that this investigation was going on and how widespread it was. So, and I think if I have the calendar right, we're coming on a year. It's about a year anniversary since that hit us. So, what was going on? What's the SolarWinds investigation?
So for many of you who are aware, SolarWinds, had a major state actor hack in late 2019. And ultimately, what happened is they handle security software, and so they were selling their patches to customers. And as soon as a customer would install this securities patch or upgrade, they were in essence corrupting their own system. So when all of this came about, very, very high profile, the SEC obviously did an investigation, of SolarWinds, and presumably, as we would all expect, it's very likely that one of the requests was, give us all the name of your customers. So lo and behold, in June of 2021, almost a year ago, out of nowhere, there were suddenly just these emails that appeared from, what looked like the SEC address, this mail address, asking for information. And sort of the irony is that, a lot of the recipients actually thought it was spam or, an attempt to hack. So a lot of people didn't even open it. But what it was and what the SEC sought, it was a sweep. And what the SEC was trying to understand is consistent with what we've talked about. What are your control systems around disclosures and internal controls? And did you have adequate controls around this massive, massive incident? And so what they sought, in the way that the SEC went about it was even a little different than some of its other sweeps. It was signed by the then acting director of enforcement, who was Melissa Hodgman. There was no contact person. There was this alias email, and you would ask a question on the alias email, and you would get a response by Steve. No last name, literally. And so, clients, probably a number of you had clients or were actual recipients of this, and everybody was really scratching their heads trying to understand how to respond, because it asked 5 questions. And if you answered all 5 questions, you were given what's called conditional amnesty as to SolarWinds. So even if you didn't disclose and you had a problem, if you told the SEC about it, providing there wasn't insider trading and, other bad acts, you would get a pass. So the kinds of questions that they were, trying to ascertain is, number 1, were you a victim? Number 2, what did you do if you were a victim and you were compromised and there was harm? What were your incident controls in place? What did you do to remediate? And then, of course, there was the question of, did you disclose? So you answer all of those questions relating to SolarWinds. The kicker is, the last question was, oh, and by the way, notwithstanding what we want to know about SolarWinds, tell us about any other compromise that you've had that lasted over 24 hours. And, what happened, and did you disclose it? And, clearly that was, an attempt for a freebie, to understand if there were adequate controls, both on the internal controls and the disclosure side. But there was a lot of discussion, in advising clients how to respond to that, because it really gets down to materiality. And are you going to, disclose something that, lasted for a day but wasn't material? And so that was a real, a real challenge in dealing with that. And so I think, the SEC is following up, to the extent there have been some situations where maybe an issuer or a registrant, or the issuers were both public and private companies, but if they had some significant impact. But it definitely shows, if you want to call it the aggressive nature of enforcement or proactive, this was a very good example of that. And the kinds of things that they're asking for and are focused on it really lays the groundwork for the rulemaking, I think, that we're going to talk about next.
Yep. No, absolutely. And I'll say on that amnesty provision, there was a bit of a hook there, which was, to get amnesty, you also had to report before your answer anything that you hadn't reported but should have.
Right.
So, okay, what if I don't think I had to report something, but the commission thinks I should have? Well, I think the way you read it is you don't get amnesty for that. So to really get amnesty, you almost had to sort of confess to having not reported something that you should have. And I know, certainly in my experience, I'm sure Susan's and most others, SolarWinds was not a material event for most companies.
Exactly.
So there was nothing for them to disclose. So it was a little bit of a conundrum, on this idea of amnesty, but you got to disclose something that you should have but didn't. But actually, there wasn't anything we should have disclosed but didn't. So how does the amnesty work if the commission later disagrees with your assessment? So it was pretty tricky. As Luke, I don't know, do you have any, from your perspective as CISO, do you have any sort of observations or takeaways from that?
I mean, I think it was mostly covered, but the main issue, many companies, one, I think there was a vulnerability management issue. It's sort of a technical operation, but it is something that has been increasingly under the spotlight by the SEC and some of their guidance in terms of how that is handled. Most organizations, in part for what you mentioned, Rob, in terms of it wasn't sort of a material issue from their standpoint, or they didn't view themselves as a significant sort of victim in that sense. Some of the sweeps, I think, were a little bit of a preview in terms of the ones that got them in terms of what might be of interest for future issues as well, in the sense that organizations that do potentially have elements of material concern would want to think about these things when they get these types of inquiries that many organizations just sort of wrote it off as, I'm just going to patch this vulnerability and I'm going to move on. They didn't really exercise much due diligence in that sense. And by the time that they either got initial inquiry or a follow-on, many of them didn't have the appreciation that perhaps the SEC may learn new information elsewhere, or that they may, as part of some of these more significant widespread issues, they need to actually be more thoughtful about their vulnerability mitigation. And so I think that was just sort of a good preview in a sense for, what organizations actually need to be thinking about, for future inquiries, I guess you could say.
And if all this enforcement work weren't enough, we now have these incredibly broad new rule proposals that Susan referred to. And I think, harkening back to an earlier panel, if you package together the rule proposals on climate and ESG disclosure and the new rule proposals on cyber disclosure, it's really a tremendous proposed overhaul of, a huge swath of potential public company reporting. So Brent, if you could pretend you're a policy SEC, lawyer instead of an enforcement lawyer for just a minute, before we ask Susan to walk us through the proposal, what's the background? Sort of what leads up to this?
Yeah, so look, I think stepping back to where we've been up until the proposed rule, our touchstone has been the 2018 Commission guidance. I think the Commission has actually given quite a bit of guidance in the context of cybersecurity, the most prominent being the 2018 Commission guidance. And that really touched on three things, which was, if you're going to make disclosures about cybersecurity risks or incidents, they need to be timely and complete. And then there was a really big emphasis, and again, we've sort of touched on this theme multiple times here, on the need for disclosure controls and procedures. And then also, a topic that Mabel will touch on in the end, this notion of the need for insider trading policies that kind of address the context of a cybersecurity incident. So I think that 2018 guidance is really the backdrop for the proposed rules. They build upon that 2018 guidance in a couple of ways. And really the goal is to create a disclosure regime related to cybersecurity risks and incidents that ensures that the information that investors get, and investors definitely want information in this space, that information is timely, complete, and helps to make valuable decisions. So part of the idea being, although a lot of public companies, as the proposed rules recognize, are already making disclosures about cybersecurity incidents and risks, to do it in a way that's consistent so that an investor can evaluate it to make decisions as to whether they want to invest in that company. And again, I think we really need to step back and think of, what are we talking about when we talk about the type of cybersecurity incidents that could hit a public company? Obviously, all throughout the news, right, we're talking about existential risk. So that's why investors really want to understand, okay, when I'm looking at a company, is this a company that takes this seriously? Do they have resources in place? Do they have policies in place? and then also to make sure that I get information about it in a timely manner, not months and sometimes years after the fact. And obviously the proposed rules kind of talk about some of the situations where that didn't occur. It certainly recognizes that public companies have been doing a lot in this space, and it's not sort of writing with a blank slate to say that public companies have sort of ignored the space, but it's to make it in a way that's more consistent and timely and complete. And I know Susan's going to walk through the details, but it really does it in two sort of broad ways, and then which I think are useful to think about as having built off the 2018 guidance. One of the things that was noted about the 2018 guidance is there was no mandatory 8K regime, and obviously that's the proposed rule would do that, right? There would be mandatory reporting for material events, and then also sort of enhanced disclosures about cybersecurity policies and governance. And so, with that, obviously these are proposed rules, so kind of weighing in more at this point would be difficult, or kind of how it will be enforced is obviously not something we could do, but that's the genesis of it.
Yeah, and just 2 quick points to follow up on that. So one on the trading point Brent mentioned, I think it's a great point. And from a practical perspective and working with clients that have had cyber incidents, one of the first things you have to talk about is trading, and it's not something you naturally think of. But especially when you don't know how significant the event is, from day one, you have to say, okay, who knows about this? Who's working on it? And let's lock down trading. We do not want anybody who's involved in the response, trading, and then it turns out it becomes some big issue and impacts the stock price. The commission sees it, they looks to see who traded. Lo and behold, somebody at the company who was working on the incident traded. So you don't normally think of it as trading. And then the last point Brent mentioned on enforcement, I think the reason why we're discussing these rules, here is that if they're adopted in any, form like what they're proposed as, it's a huge new area for enforcement, right? All kinds of required disclosures, board composition, all kinds of things. So it's potentially a real broadening of exposure for public companies on cybersecurity issues. And so with that, Susan, as usual, it's some humongous document, this rule proposal. Can you walk us through the highlights of what would be required?
I will give you the bullet points, and then we're going to flesh out some of the things. But again, in consistent with what we've done today, I'm going to quote what Commissioner Peirce said about the rule, which was because it is very broad. She suggested that they, and this is her quote, flirted with casting the SEC as the nation's cybersecurity command center. And when I walk through some of this, you can see where there's just going to be a lot of tension. So the first thing, and Brent touched on this, is on the requirement for disclosure. Under the new rule, a proposed new rule, is that there needs to be an 8K disclosure within 4 days after there has been a determination that a company has experienced a material cybersecurity incident. And it made it clear that it wasn't discovery of the incident, but it was a determination. Incident, by the way, is defined as an unauthorized occurrence. So, it could be a number of things from threat actors, or, it could potentially be somebody who clicked "your order is ready" from Amazon.net and, shuts your system down. But in any event, it's a very fast turnaround. And the other piece, and we'll talk a little bit about this, is that there's not an exception if you've reported to state or criminal authorities. And, I know we've had clients where you are the victim and you go to the FBI as a victim would do. And, the FBI is working to try to shut down the problem and do what it can to try to stop what's happening. And the ask is, do not report this to anyone. And the SEC's view is, and I've had them, the staff say this to me even before this rule you went to the FBI, why didn't you come to us? Well, now if this rule is passed, that would be a requirement. There's also, at least as I read it, a duty to update. And that duty to update comes in the form of your quarterly or annual disclosures on 10K and 10Q. And you have to discuss, among other things, the material effect of the incident on a company's operations and financial condition. You have to talk about what potential material future impacts could have come about, whether or not the company has remediated or is currently remediating, and any kind of changes in procedures or policies as a result of the incident. So you really almost have to open up, what you've done, what you found, and kind of, perhaps fall on your sword. This piece has really been the biggest source of public comment, and the public comment deadline was on May 9th, and I don't know if anyone's had to take a look at it, but I think it's fair to say you're not seeing comments along the lines of, this is great, we're happy to see this. It is, things along the lines, and particularly the Chamber of Commerce, that you're putting the company at risk by disclosing these things, because you're basically causing the company to disclose what its vulnerabilities are by requiring, and this 4-day determination potentially would require a company to disclose before they've really resolved what the issue is. And there could still be things happening within your system that haven't been resolved, and you've got threat actors that are posting things on the dark web. So it's gotten a lot of that's very, very controversial. Also requires periodic disclosures around the company's strategies concerning cyber risks, including policies and procedures about risk assessment. Do you have experts or consultants who are helping you? There's also a requirement that you disclose, management oversight. What is management doing to implement these policies and procedures? And then a discussion point that we'll talk about a little bit later is on the board oversight. There is, now a requirement that a company disclose whether the entire board or specific members of the board have cyber, expertise, or is there a cyber committee? And how does the board receive information about disclosure, about cyber incidents? So very, very, very extensive. And I'll just give you the final word before we flesh out some of this of what the Chamber of Commerce said on this, among other things, in a very lengthy letter. But it said, by requiring companies to disclose the nature of an attack before it is resolved, a disclosure of vulnerability data could actually enable attackers. This is not in the interest of the company or its shareholders, and therefore the proposed rules miss the mark on investor protection. The Commission should focus on coordinating with other federal agencies on incident reporting where appropriate, instead of creating a new regulatory regime that would contradict, if not undermine, the work of other government entities. So it's kind of along the line of what Commissioner Peirce said. So it'll be interesting to see what the final rules look like.
And I think common to rule proposals we've seen in the past where the Commission wades into sort of social policy issues, instead of directly saying, company, you must have this policy, you must have this person on the board, you must do things this way, it's sort of a backdoor way into requiring it by saying, oh, you just have to disclose it. Right now you put companies in the position of, okay, am I going to disclose that I don't do that? Really? Like, what are my peers going to do? So instead, without going through the effort of saying, what's the cost-benefit analysis of requiring companies to do these things, they're just requiring disclosure. But essentially, requiring disclosure, I think, fairly clearly is an effort to require the underlying, acts themselves. All right, so Bruce is up here. We're down to our last minute or two. I'm going to jump to just one other thing. Speaking of the breadth of the Commission's rulemaking, effort the past year. Luke, if I could ask you just in our last minute, there's also proposed rules involving cyber on investment advisors. Can you maybe just give us a highlight of that so people are aware of it before we wrap up?
Sure.
And sorry for skipping around.
Yeah, I'm just kind of jumping down to my notes as well. I saw we were running short on time, but there are similarities between some of the public company guidance elements of hygiene, governance, as well as incident reporting. It got more specific into certain controls, particularly around things like multi-factor authentication. I would add, and this is in part out of a conversation that that I had about a month ago in a similar platform with the cybersecurity docket with Christy Lippman, but just really unpacked aspects of those controls and ultimately in the spirit of protecting the investors that they're stewards of and their information. But ultimately, my takeaway was it spoke to hygiene, it spoke to governance, and maintaining consistent controls from a cybersecurity perspective that essentially protect the information of the investor.
So just wrapping up, like the cyber over the last year, we've had an enforcement case on disclosure, an enforcement case on disclosure controls, the SolarWinds investigation that literally impacted hundreds of companies, proposed disclosure requirements on public companies, proposed new procedures for investment advisors, and I think we all sort of expect something to be coming on broker-dealers potentially too. So just in the past year, just an incredible amount of activity from the Commission on cybersecurity.
Thank you, Rob. Great job. All right, we have one last panel, one more rockstar panel about internal investigations, followed by a cocktail party. So I hope everybody will stick around. Thank you.